Cool. Okay, so you ever want to read something and then you just kind of feel like, I really got to read this. I found something on my computer. Here it is. Yeah. Have you ever heard of the maxims of law? I saw something here. This is principles of jurisdiction. And it's got to do with the courts. Well, I wanted to read this because I saw this on 33, by the way. Here it is. What did I just do? I hate it when that happens. Go back. There it is. See right here. It says equity will not suffer a wrong without a remedy. Isn't there a lot of people? Well, I don't want to say suffering means allowing, but that's kind of what this word means. But a lot of people are going through a lot of things that are wrong right now. But hey, it says right here, equity will not suffer a wrong without a remedy. So let's read this. This maxim and the maxim that equity operates upon the person are two of the principles most active in originating and molding the Chancery jurisprudence. The king, as the fountain of justice, with an oath resting upon his conscience to see that right was done to all his subjects, and believing that he had done, that had the prerogative power as the supreme judge of England to do whatsoever he deemed was right and just as between man and man, without reference to laws, customs, statutes, precedents, or courts, and prompted no doubt by his ecclesiastical chancellors, was not willing to see a wrong done to a subject. Not that we want to be subjects or anything, but I'm just saying. And to be told that there was no power in his kingdom to right that wrong, that the common law furnished no remedy therefore, and that as a consequence, the wrongdoer in that particular was superior to the law and mightier than the king. Hence was it that the king, deeming such a state of facts derogatory to himself, disparaging to his prerogative, disgraceful to his kingdom, and a dereliction of duty under his oath, took personal cognizance of such matters when petitioned to do so. Because he's God, right? Whatever. And when petitions became too numerous for his personal attention, he referred them to his chancellors, who were the keepers of his conscience, with authority to do whatever good conscience and good reason required in the premises. The common law had a maxim, ubi jus ibi remedium. Wherever there is a right, there is a remedy for the violation of that right. Let's read that again. Wherever there is a right, there is a remedy for the violation of that right. Hello. I'm just saying, there's a lot of great examples going through my head, and I think I won't say them all. I'm just saying, but the maxim was too general to be true. Had it been true, there would have been no need for a chancery court. This is in England, by the way. To support this maxim, it was held that if there was no remedy, then there was no right, which was the same as saying that the right depended on the remedy. And unfortunately, for the common law, this was true. For under the common law, every cause of action had to be adapted to some one of its technical and arbitrary forms of suit. And if this could not be done, then the suit could not be brought. So that at common law, the right had to be adapted to the remedy, thus violating at the same time both reason and justice. In the Chancery Court, the opposite rule was adopted and enforced, and the remedy was adapted to the right, and thus made to assume any form the right required. This maxim, or as it is sometimes expressed, equity will not suffer a right to be without a remedy, is the original source of the entire equitable jurisdiction. Let's see if I can change this. Of the Chancery Court, exclusive, concurrent, and auxiliary. It's late. Okay, so, and a full explanation of the scope and meaning of this maxim would require discussion of the whole system of equity. And now that the jurisdiction of the Chancery Courts has been so greatly enlarged by statutes in Tennessee, the force of the maxim and its beneficence have been proportionately enlarged. You can tell this was done in the 1800s with some of these words. The wrong that equity will not suffer to be without a remedy must be a civil injury to the complainant's rights or interests, legal or equitable. There are some duties equity does not attempt judicially to enforce, such as charity, gratitude, and kindness, and some wrongs with which equity does not interfere, such as violations of honor, hello, or of truth, hello, or of morals, hello, involving no question of property and no question of pecuniary liability, but any wrong done to a legal or equitable right will be redressed in equity, unless some other court has exclusive jurisdiction. This maxim was originally intended to mean that in all civil cases within the scope of judicial action where a wrong had been done or was threatened to be done, and a full, complete, adequate, and certain remedy could not be had in the common law courts, a remedy would be provided and enforced in the Chancery Court, and all jurisdiction assumed necessary for that purpose. And in order to enable the court to adequately exercise this jurisdiction and to make its remedies effective without coming into conflict with the powers or processes of the common law courts, the plan was devised of compelling the defendant himself to execute the decree of the Court of Chancery by imprisoning him, if necessary, until he did so. Hence, the maxim, equity acts upon the person. Whoa. And it might be said that on these two maxims hang all equity. So it does have to do with how we act as the person in a court. And apparently it says right here, in order to enable the court to adequately exercise this jurisdiction and to make its remedies effective without coming into conflict with the powers or processes of the common law courts, the plan was devised of compelling the defendant himself. We have to go there to execute the decree of the Court of Chancery by imprisoning him, if necessary, until he did so. Whoa. That's wild. It really is up to us. That's wild. Whoa. In pursuance of these two maxims, the Court of Chancery has devised or adopted from the Roman, all roads lead to Rome, or civil law, the following remedies, none of which existed at common law. Number one, specific performance of contracts. Number two, injunctions to restrain the violation of rights, to stay unjust proceedings at law, to quiet title and prevent wrongs. Number three, the re-execution of instruments lost or destroyed. 4, the reformation of deeds, or contracts, erroneously drawn by accident or mistake. I made a mistake. I signed that ticket. I signed that deed, that contract, made a mistake. So the rescission, number 5, the rescission and cancellation of agreements and conveyances obtained under circumstances of surprise, fraud, or mistake. The reopening of settlements, this is number 6, and adjudication of complicated accounts. Oh, that sounds good. Number 7, the method of winding up all the affairs of a partnership. 8, the marshaling of securities. That sounds good. I want all the bonds, please, for this case. Thank you very much. I have my subrogation rights. 9, the redemption and foreclosure of mortgages. 10, the partition of land between tenants in common. Okay. 11, the enforcement of trusts and fiduciary obligations. 12, the exoneration, contribution, and subrogation of sureties. That sounds good. 13, the administration of estates. That sounds good. Does it? I don't know. What does that mean? The administration of estates. Are you administrating a trust today? Is that what they're doing? 14, the winding up of the states of insolvent debtors and insolvent corporations. What does this mean? 15, the enforcement of liens. 16, the protection of the persons and estates of infants. Interesting. 17, the establishment of a wife's equity. 18. Wow, that's good. 17. I like that one. That's good. 18. The remedy by interpleader. I have to look that word up. I'm too tired to do that right now. But interpleader, we'll have to look that one up. 19. The perpetuation of testimony. Oh, that's good. And 20, a discovery in aid of legal proceedings. Thus, upon these two maxims, equity will not suffer a wrong without a remedy. And equity operates upon the person, was builded was builded, that grand structure of jurisprudence called equity. And although by means of the improvements in the processes of the courts, aided largely by wise legislation, remedies for every civil wrong known to the courts have been devised and enforced. Yet, if in the process of civilization, if in the complicated network of mercantile business, if through the ingenuity and subtlety of the human mind bent on schemes of personal or pecuniary advantages, or intent on devices for aggrandizement, new remedies should be required to circumvent circumvention and to overcome the insidiousness of any sort of Machiavellism. The Court of Chancery, operating in obedience to this maxim, will devise a remedy adequate to the emergency and vindicate the beneficence and capacity of its inherent powers to do justice in any case and to right every wrong, however intricate. Oh, that's good. However intricate the case, however great the wrong, and or however powerful the wrongdoer. Good. The powers that lie dormant in this potent maxim will awaken as the necessities for their action arise, and they will be found commensurate with every necessity. I don't know what commensurate means. Is that like commiserate? Commensurate? I don't know. With every necessity. It must not be forgotten, however, that this remedy, may be forfeited or lost by the party wronged. Forfeited, number one, by some fraudulent, illegal, or unconscientious conduct in connection with the wrong he complains of, whereby his hands have become stained with iniquity. Oh, so don't be having your hands dirty now. Or number two, by having through his fault or negligence occasioned or contributed to the loss complained of. For when one of two persons must suffer, the loss must be borne by him whose act caused it. That sounds good. Or the remedy may be lost. Oof. By the fact that the adverse party has an equal or a superior equity, or by latches. It's not lashes, it's latches. Lashes. By lashes. Or acquiescence, or by subsequent contract or estoppel. We don't want the remedy to be lost. By the fact that the adverse party has an equal or a superior equity, or by latches, or acquiescence, or three, by subsequent contract or estoppel. 34, let's just keep reading for a second here because this is good. Equity acts specifically and not by way of compensation. This principle runs through the whole system of Chancery jurisprudence. Equity aims at putting the parties exactly in the position they ought to occupy, giving them in specie what they are entitled to enjoy, and putting a stop to injuries which are being inflicted. Thus, equity decrees the specific performance of a contract instead of giving damages for its breach. So equity restrains the commission of a trespass instead of compensating the aggrieved party by damages. In some cases, also, a party will be compelled to specifically make good his representations by which another has been misled. Oh, that's good. So equity will declare a person who has knowingly acquired trust property a trustee and will make property purchased in his own name by a fiduciary with trust funds. Trust property will construe and enforce wills and other express trusts, and will set up lost or destroyed instruments and records, and will cancel fraudulent deeds and remove clouds on title. Ooh. And will, by injunction, protect a party in his rights or restrain a party in his wrongs. In all the foregoing cases, the common law either gave no remedy or else merely allowed damages for the wrong. The latter remedy, when allowed, being often wholly inadequate and sometimes from the poverty of the defendant, wholly worthless. I don't exactly know what that sentence meant. In all the foregoing cases, the common law either gave no remedy or else merely allowed damages for the wrong. The latter remedy, when allowed, being often wholly inadequate and sometimes from the poverty of the defendant, wholly worthless. Right. Like you get nothing usually before. So 35, when parties are disabled to act, the Chancery Court will act for them. Oh, is this why we want to claim to be disabled? I am legalese disabled. It's true. How are we supposed to know this stuff? Hello? We didn't go to law school, I'm just saying. When parties are disabled to act, the Chancery Court will act for them. Persons of unsound mind, oh, yeah, you don't want to claim that, are disabled to act for themselves by nature. Infants are disabled both by nature and by law, and married women are disabled by law alone. Is that so? And married women are disabled by law alone. Well, good thing I'm not married then. Just saying, divorced. As a rule, none of these three classes can of themselves enter into any important contract. That's heavy duty. So if you went and bought a house, wow, and you're a married woman, yeah, wow, they're saying that you can't, wow, those three classes can of themselves, wait, none of them, none of those three can of themselves enter in any important contract. Wow, especially contracts relative to lands. Whoa, that's cool. Oh, but it is often of great importance to their welfare to convert their property into another form, or to expend it for their urgent necessities. And the law would be greatly defective in this important matter if it furnished no remedy for such emergencies. That's a good kind of an emergency. That's cool. This is good right here. The Chancery Court gives this remedy and has full jurisdiction to do everything necessary for the welfare of persons under disability. That's interesting. So you could say, I'm sorry, I'm disabled. I have a legalese disability. Legally disabled. Because legalese, I don't understand it all. It may sell, lease, or exchange their lands. What? Convert personality into reality. Realty into realty. Or realty into personality. Order the expenditure of any part of the principal act indispensable to their welfare. The court at all times having in view the best interest of the parties and acting as would a prudent and considerate parent. Oh. So that's what they're doing, huh? There are parents. Parenti. 36. Let's just see what this is here. When Chancery has jurisdiction for one purpose, it will take jurisdiction for all purposes. When Chancery has jurisdiction for one purpose, it will take jurisdiction for all purposes. This maxim is not always so broadly stated in the reports and textbooks, but in the light of the Act of 1877 extending the common law jurisdiction of the Chancery courts, there could be no doubt about the correctness of the rule as given. Pomeroy states the rule thus: where a court of equity has obtained jurisdiction over some portion or feature of a controversy, oh, this is good, it may and will in general proceed to decide the whole issues. Oh, this is good. And to award complete relief, although the rights of the parties are strictly legal, and the final remedy granted is of the kind which might be conferred by a court of law. The reason of the rule is the duty of courts to prevent a multiplicity of suits. Yeah. And courts of equity delight to do complete justice. I'll take a court of equity. And not by halves. Our Chancery Court acted in accordance with this rule prior to the Act of 1877, and it may now be considered as an invaluable rule and one attended with very beneficent results. Where suits are brought to enjoin the further prosecution of a pending action at law, or the enforcement of a judgment recovered at law, either on the ground of some equitable defense not cognizable by the law courts, or on the ground of some fraud, mistake, accident, or other incident of the trial at law, which rendered the legal judgment inequitable, in such cases, a court of equity, having obtained jurisdiction, this is good. So you're going to want a court of equity for sure. Having obtained jurisdiction for the purpose of an injunction, will decide the whole controversy and render a final decree, even though the issues are legal in their nature and capable of being tried. I would like to just print these 3 pages out, man, and send them all over the place. And capable of being tried by a court of law, and the legal remedies therefore are adequate. This rule is general in its operation and extends to all suits brought to obtain the special relief of injunction, and is not confined to suits for the purpose of enjoining actions or judgments at law. It may be stated as a general proposition that wherever the Chancery Court has jurisdiction to grant the remedy of injunction for some special purpose, even though the injunction covers only a portion of the controversy, it may go on and decide all the issues and make a final decree, granting full relief in the same manner as could a court of law. This is so good. Man, I want some justice going on here. Decreeing damages for the wrongs enjoined when proper. Particular instances of the operation of this general rule concerning the remedy of injunction may be seen in cases of waste, of private nuisance, and of continuous or irreparable trespasses, where the Chancery Court, having obtained jurisdiction by injunction, will complete the relief the complaint is entitled to by decreeing him damages for the injuries done. If the Chancery Court obtains jurisdiction of a suit for the purpose of granting some distinctively equitable relief, such, for example, as a discovery or the specific performance of a contract, or the rescission or cancellation of some instrument, and it appears from facts disclosed on the hearing, but not known to the complainant when he brought his suit, that the special relief prayed for, oh, there you go, that's that word. I want special relief. I am praying for special relief, for has become impracticable, and the complainant is entitled to the only alternative relief possible, that of damages. The court then will, instead of compelling the complainant to incur the double expense and trouble of an action at law, retain the cause, decide all the issues involved, and decree the payment of compensatory damages. It is fundamental rule of equity jurisprudence that the Court of Chancery, in any cause coming before it for decision, if the circumstances of the case permit, and all the parties in interest are or can be brought before it, will determine the entire controversy and award full and final relief, and thus do complete justice to all the litigants. Excuse me. Whatever may be the amount or nature of their interest or liability, and thus to bring all possible litigation over the subject matter within the compass of one judicial determination. By virtue of this rule, and in order to promote justice, the court, having obtained jurisdiction of a controversy for one purpose, will extend its judicial cognizance over rights, interests, and causes of action which are purely legal in their nature, and will award remedies which could have been adequately bestowed by a court of law. All this could have been done before the Act of 1877, and since that act, the rule herein stated has become one of the ordinary jurisdiction of the court. 37. The Chancery Court never loses its jurisdiction by implication. Exactly what effect our Constitution has on the stability and jurisdiction of the Chancery Court has not been determined. That this jurisdiction can be increased is certain, but is doubtful whether its equitable jurisdiction can be taken away or even seriously impaired. The system of equity jurisprudence is tacitly recognized by the Constitution as a part of the fundamental law of the land. Hence, all the stronger in Tennessee is the rule that a court of equity never loses its jurisdiction by implication. In all cases where the court had originally jurisdiction because of some want of adequate remedy at law, the jurisdiction is not lost by the fact that the courts of law now give a remedy. The jurisdiction of the Chancery Courts cannot be made thus to ebb and flow. Their jurisdiction must be permanent and must remain fixed until changed by a new constitution or by the legislature acting within the present constitution. The common law judges cannot diminish the inherent jurisdiction of a court of equity by enlarging their own jurisdiction. And when the legislature enlarges the jurisdiction of the common law courts, the rule is well settled that unless the statute shows a clear legislative intent to restrict or abolish the jurisdiction of the Chancery Courts, such jurisdiction will continue unabridged. For without some positive act, the just inference is that the legislature desires the jurisdiction and equity to remain upon its old foundations. 38. Equity delights to do complete justice and not by halves. I like this one. This maxim has grown out of the desire of the Chancery Court to so completely decide every matter involved in the litigation that there will be no roots of controversy left out, of which other suits may spring. Ooh, yeah. Yes. Hence, the court requires that all persons interested, either legally or beneficially, in the subject matter of the suit, shall be made parties to it, either as complainants or by defendants, so that there may be a decree that will bind them all. By this means, the court is enabled to make a complete decree between all the parties interested in the controversy. And thus not only to prevent future litigation by taking away the necessity of a multiplicity of suits, but to make it perfectly certain that no injustice has been done to any party interested in the subject matter of the suit. This, too, is one of the purposes of the court in enforcing the maxim, he who seeks equity must do equity. For by giving the defendant his rights in a cause, the court not only does justice in full and not by halves, but the defendant is relieved from the necessity of instituting a suit in his own behalf. That's good. It is the constant and zealous aim of the Chancery Court to so frame its decree as to adjust and compose all disputes as to all matters legal and equitable involved in the controversy. A court of equity will always do directly what can be done indirectly or circuitously, and will strive to prevent a multiplicity of suits. That's good. Formally, the jurisdiction of the Chancery Court ended where that of the Circuit Court began. Oh, interesting. And as a consequence, it was often unable to do complete justice. That's what we've been getting, those circuit courts going in circles. But after doing half justice, was obliged to remit the complainant to the Circuit Court for the other half. This was especially true. Number one, on bills to remove a cloud or recover land. The complainants, after recovering the land in the Chancery Court, were obliged to go to the Circuit Court to collect the rents and profits. Ooh. Number two, on bills to enjoin a nuisance. The complainants, after having the nuisance enjoined, were remitted to the Circuit Court to recover their damages. Ooh, that sounds good. 3, on bills for a new trial, the parties complaining after proving their case in Chancery were remitted to the Circuit Court if plaintiffs there in order to obtain a recovery. 4, on bills to set up lost deeds, notes of hand, or other contracts, the complainants, after having their lost instrument set up in Chancery, were obliged to resort to the Circuit Court to have them enforced. 5, on bills to enjoin waste, after a perpetual injunction was had in Chancery, the complainants were remitted to the Circuit Court to get compensation for the waste committed. Cool. 6, on bills to reform instruments, after getting them reformed in Chancery, that's what we want, the complainants were obliged to go to the Circuit Court to obtain damages for their breach or recover what was due on them. 7, on bills to enjoin a defendant in the Circuit Court for making an inequitable defense, or to enjoin a plaintiff from asserting an inequitable claim. After obtaining such relief, the suits in the Circuit Court were often left pending. 8, on bills to declare the defendant a usurper, the complainant was given the office but remitted to further litigation to recover his fees. In most of the above instances, the Chancery Court now administers full justice, its hand being no longer stayed by the fear of trespassing on the domains of the law courts, and the disposition of the chancellors now is to disregard decisions and precedents obsolete since the Act of 1877, and administer justice to the full extent of their jurisdiction, and no longer remit a party to the circuit court or force him to institute a second suit when all the questions involved in the litigation or incidental to it can be effectually determined in the suit pending in the Chancery Court, so that the partial or half justice is now very seldom administered. 39, he who seeks equity must do equity. Under the operation of this maxim, courts of chancery are enabled to adjust the equities of the complainant to the equities of the defendant, and thus do complete justice between the parties. Formerly, it was the practice of the court to refuse relief to the complainant unless the complainant would acknowledge or concede or provide for the rights, claims, and demands justly belonging to the defendant and growing out of or necessarily connected with the subject matter of the controversy. The ecclesiastical chancellors sought to enforce in their courts the divine injunction of doing unto others as we would have others do unto us, which is only another form of the maxim. But now the Court of Chancery does not wait for the complainant to offer to do equity, but acts on the supposition that, knowing the rule of the court, he is willing to do whatever equity towards the defendant the court may require of him. Number one, if a borrower of money upon usury seeks the aid of the Chancery Court to have canceled the insurance contract, the court will require him to do equity by paying the lender what is legally due him. 2, if a taxpayer seeks relief from an overassessment, he must pay what is justly due. If a party seeks to have a tax deed declared a cloud, he must pay all the taxes paid by the holder of the deed. What's that? 3, if a party seeks to have a tax deed declared a cloud, to hide it, right? He must pay all the taxes paid by the holder of the deed. Oh. 4, if a person asks for partition, he must pay his proportion of any encumbrance removed by the defendant. If a husband, this is 5, if a husband seeks the aid of a chancery court to reduce his wife's personal estate to possession, he will be required to do equity to the wife by allowing the court to settle upon her, for the sole and separate use of herself and children, a reasonable portion of the proceeds of said estate. 6, if the owner of land allows another to make improvements thereon under the belief that he has the right, a court of chancery will compel such owner, seeking to assert his title, to pay for such improvements. 7, where a complainant seeks to have a certain fund decreed to him, he will be required, if insolvent, to pay the defendant what he owes him. 8, where a complainant has his deed declared a mortgage, he must pay the consideration he received. 9, where the complainant obtains the rescission of a contract or the cancellation of an instrument, he must make the defendant whole. Interesting. 10, where a married woman avoids a sale, she must restore the consideration she received. 11, a mortgager will not be allowed to redeem without paying an encumbrance discharged by the mortgagee. 12, a judgment will not be encumbrance or enjoined unless complainant pays what he owes the judgment creditor. And in 13, in general, whenever a complainant seeks to recover property from which the defendant has removed an encumbrance, or to the value of which the defendant had added in good faith, relief will be granted the complainant only on condition that the defendant be reimbursed to the extent the complainant has been by him benefited. It will thus be seen that in giving the complainant relief, a court of chancery will require of him whatever the defendant may, in good reason and good conscience, be entitled to in reference to the subject matter of the suit. Although this requirement may be one the court would not otherwise enforce, the condition thus imposed on the complainant is, as it were, the price of the decree the court gives him. Under this maxim, an equitable right may be secured to the defendant, which could not be obtained by him in any other matter, which he could not have secured by a suit brought for that purpose. The equity the complainant is required to do must, however, be connected with the subject matter of the suit, or grow out of the very controversy before the court, and conditions must not be arbitrarily imposed. The principle contained in this maxim enlarges the powers and jurisdiction of the court when equities arise in favor of the defendant out of the subject matter of the controversy, and hence this might be termed a jurisdictional maxim. It also enables the chancellor to determine the whole controversy in all its branches, and if necessary, to make a sort of equitable compromise decree giving to each party what in good reason and good conscience he ought to have. Sorry, I dropped my mouse. And requiring of each what in good reason and good conscience he ought to do, thus fulfilling that other maxim, boni judice et slitus dirimir, elis ex lit oiter. It is the duty of a good judge to so thoroughly decide a suit that another suit will not arise out of it. And I'm going to finish here, but I just wanted to read 40. Courts of equity will not tolerate any interference with their officers' process or decrees by the courts of law. It sounds really good, but I'm getting tired. It's probably like 11 o'clock tonight. But I just wanted to read, and I needed to get some stuff situated before I could do this, so I'm going to stop sharing. Tired. Okay, well, hopefully we'll learn and continue to be able to help each other with what we learn. Okay, have a good night. Good night.